Welcome, ladies and gentlemen, and thank you for tuning in to the National Fraternal Order of Police Labor Services Division podcast series on labor issues, sponsored by the Labor Services Division and inspired by National Fraternal Order Police President Patrick Yos. My name is Michael Coviello. I am the Associate General Counsel for the Division of Labor Services of the National Fraternal Order of Police. I've been practicing law for over 30 years, and over 25 of those years have been in some capacity representing FOP members. First, as a contract attorney on the legal defense plan, representing officers involved in critical incidents, as the General Counsel for the Florida State Lodge, and now as Associate General Counsel for the Division of Labor Services.
Good morning. My name is Steve Egan. I'm a labor specialist with the Fraternal Order of Police. I worked in law enforcement for over 24 years. I retired at the rank of lieutenant, supervising the training division and our active shooter use of force program. Prior to that, I was a shift commander for several years, as well as supervising our detective unit. I'm a use of force instructor, a firearms instructor, and I'm certified by the Force Science Institute as an advanced specialist.
Ladies and gentlemen, welcome back. Well, we are now in part 2 of the Critical Incident Podcast. With me here again is Steve Egan. What we're going to talk about now is the investigations themselves and how those investigations proceed, how you want to protect yourself and make sure that officers are protected in that process, and in doing so, how the agency, the employer, is protected as well. So, as we talked about last time, Steve, there are going to be a series of investigations. We have the court of public opinion, the media, there's a policy investigation, the so-called internal investigation, and there is a criminal investigation. And this is the part that often gets lost in the translation. Like it or not, justified or not, reasonable or not, the deployment of lethal force that results in the death or serious bodily injury of a suspect results in a criminal investigation. Now, in order for there to be a criminal investigation, there must be a suspect or subject of that investigation. And as much as it feels painful to say or even acknowledge, the fact is the officer is now the suspect in a homicide investigation where you have this, or in that use of force investigation. And it's really imperative that we get accustomed to that, right? Now, from a legal perspective, it's clear that if I'm representing somebody who's accused of a crime, there are certain rights that go along with that, including the right to representation. Mm-hmm. Now, a very subtle nuance around that is, under the Constitution, you're entitled to an attorney when you're in custody, right? It's a custody scenario. However, over the development of this relationship with police agencies and officers over years, decades, we're now all relatively comfortable with the fact that there is going to be an officer on scene to represent the subject officer, even though they are not technically under arrest or in custody for Fifth Amendment purposes. But it is important to note that that representation is crucial to occur as early as possible, meaning those workers, fellow officers, get on a phone immediately, contact a legal defense plan attorney and get them out on the scene. They're on call 24 hours a day through our FOP LDP plan, Fraternal Order Police Legal Defense Plan, and they know that they get a call at 3 o'clock in the morning, they go, and they do, and it's an honorable service they provide. And it's important that the officer not provide information about the facts of the case, which we'll get into a little bit. But let's talk a little bit about what that on-scene investigation looks like and how it translates into what's going to happen in the next, let's be honest, 12 to 18 hours.
Well, so, as we spoke earlier in part 1, some of your best information is going to come from either that buddy officer, from the representative, because I'm going to show up as well, and the other FOP labor specialists are going to show up as well, to make sure that the process is followed, right? We don't want to get into specifics of the statement. There's some science reasons behind that we're going to get into. You've got your constitutional right that we want to comply with, because there's going to be some inaccuracy. So, again, the scene has now been secured. We have to methodically and take our time. That's that yellow light. There's no hurry. We can hold this scene for 16 hours. The one I was in was 14 to 15. You might be there 24 hours, depending how chaotic your scene is, how widespread your scene is. But slow it down. And again, identifying every possible witness that's out there. And again, that's going to be the labor rep is going to be able to provide the attorney some information. The buddy officer is going to be able to provide information to that attorney and to make sure that the process, that the investigation is done correctly.
Yeah, I love you use the word chaos. One of my favorite definitions of chaos is order not yet known. And so from a perception, and perception drives so much of these incidents, from a public perception, this is chaotic, right? When we know that there is actually, this happens according to a particular order, so literally beginning with an officer's life or someone else's life is threatened and the officer uses force. That's not chaotic. That's done per training. That's done in as action, reaction, as you said earlier. So all of this, what I think is very important for everybody involved to do, use that yellow light, slow down, let's create or look for the order in this, because it's not chaos. It's only chaos when we say or believe that it is. So this investigation, who gets represented? Clearly the subject officer gets represented. Now, also in a collective bargaining scenario, oftentimes these things are negotiated ahead of time. It'll be in the collective bargaining agreement that the subject officer is entitled to an attorney, even though there's not a custodial situation here. There's not an arrest. I think the best collective bargaining provisions that deal with these critical incidents also provide for attorneys for witness officers as well, because the fact is at some point they are going to be compelled to give a statement. Now, they will be compelled certainly in the administrative investigation or the internal affairs investigation, but even in the criminal investigation, they can be compelled to give a statement. And while it may not be readily apparent, they could have some legal jeopardy based on how they acted or did not act, or how it is they choose to participate in the investigation. So I think it's important for all concerned, especially law enforcement officers, for whom every disciplinary event is a potential career-ending event. So I think it's great to negotiate that everybody is represented on the scene through FOP legal defense plan. Now, that does not mean that we think anybody did anything wrong. And one of the things that I've had a very successful process with command staff is to say, look, you want, under the yellow light metaphor, you want to slow this thing down and you want to make sure that everybody's represented so that you know that everything that you put out as a result of this investigation has been vetted, not manipulated or adjusted, but vetted and presented in a way that protects all concerned, including the agency, the city, the county, the state, whoever the employer is. What do you say about that?
You're 100% right on every point. Everybody wants to get it right. And in a crime scene, you only have one chance to get it right. In an investigation, you only have one chance to get it right. So assigning counsel to everybody does no harm. It's just assuring due process and ensuring that everything goes according to procedure. The officers showed up and did their job that day. They didn't intend, unlike a criminal that's going to go out and intend to commit a crime. They responded to a 911, responded to a call for service, and they acted.
Or stumbled onto something in the process.
Stumbled onto something in the process. And a cop to a T, cops don't want bad cops working for them. Chiefs want to get it right. Everybody wants to get it right. So follow it by the books. Because even with those officers that didn't put shots downrange, there's a level of stress with them as well. And going back to that perspective, selective attention and attentional blindness, they might say something not realizing that they're saying it, and it could be incorrect.
That brings up the point of the green light, the command staff or detectives that want to get this thing all wrapped up. We got to take a statement. We got to have a statement. We got to have a statement. I'm going to talk about the wisdom of giving a statement in a criminal investigation, but at least in the policy investigation, the timing of the statement is crucial. And we have policy, best practices, recommendations from the FBI, the International Association of Chiefs of Police. They all have an agreement around this. It just seems that when we get into practice, it seems to get lost. What do you say about the timing of that investigatory statement by the subject officer?
I would say no less than 72 hours later. And the reason being is they need a sleep cycle. They've just gone through a high-pressure event. Their adrenaline is through the roof. Their blood pressure, as a result, is going to be skyrocketing. Their pulse is going to be skyrocketing. We know for a fact that our perception does not work like a camera. or a body-worn camera. So body-worn camera is just, it's passively collecting everything that's in. We are not computers. We're focused on whatever we're focused on. We have inattentional blindness as a result, and something is coming in. It may not necessarily be coded and retained. It may or may not. The sleep cycle allows for that to happen. Specific to auditory exclusion, I was involved personally in an event where the other officer with me didn't hear some of the threats that were being made because that officer was avoiding or trying to avoid the 2 feet that were trying to be kicked into his face. So these are very real issues, scientifically proven. So the 72-hour rule, let the officer sleep, let the officer get decompressed, and then we're going to transition to, with an attorney in an appropriate setting, a good interview. Go on to the days of, we don't want the interview done in the back of a squad car,
Right.
In the back of, in a suspect interview room, certainly not handcuffed, and we can go from there.
Yeah, the practice that I've had over 30 years is whenever I'm involved in one of these investigations representing a police officer, I actually have a method that I've developed over a few years. What I'll do is, obviously we're going to be in a conference room somewhere. We're going to be in an office setting, most likely, but not in a interview room, like you said. And I absolutely will not allow for that to happen. I will object strenuously and say there's absolutely no way you're putting this officer in a criminal suspect interrogation room, because the not only are the optics horrible, and by the way, you mentioned back of a police car. The last place I ever want a subject officer on a crime scene is in the backseat of a police car, because the media is going to see that and, right, what's the headline, right?
Guilty.
So the idea of setting is absolutely crucial. So we'll be in a conference room, and it's just the two of us. It's a privileged conversation. I'm an attorney. He's my client or she's my client, and we'll start talking about it. And the very first thing I'll do, I won't even have a legal pad out in front of me and pen, nothing. Just sitting there having a conversation like you and I are right now. Hey, tell me what happened. And I'll typically get a 5 to 15 second response about what happened. We'll take a little break, maybe get a cup of coffee, something to eat. All right, so let's go through it again. Tell me again what happened. And then I'll start inserting some questions along the way. And I'll do this 5, 6, 7, 8 times over the course of several hours, which in my experience, and I'm asking open-ended questions, the officer is beginning to develop some recall. Because while we all agree in principle that 72 hours is optimum to get that sleep cycle to allow for that recall, you don't always have that. You don't always get that. So preparing the subject officer in a relaxed environment, going through the recall, and I've found that the difference between that first answer of 10 to 15 seconds becomes maybe 10 minutes by the time they're putting all the detail in. And the reason why I'm doing that is because I know that they are in the investigatory statement going to be asked very detailed questions. And if they hadn't had the opportunity to consider that, now we have a potential discrepancy between what the physical evidence shows and what the officer's recall shows. And gee, how do prosecutors and the public react to that?
Yeah, they're going to charge them. And that's the default. It's just not going to look good. And you think of something as mundane as, what did you eat for breakfast this morning? Or what did you eat for lunch? What'd you do yesterday? And that's people running through life with recall issues. And
unless you eat the same thing every day at the exact same time, you'd have to think about it.
You'd have to think about it.
Right. So the other thing, too, is report writing becomes a real crucial part of this as well. When the officers are doing their incident reports or their use of force reports, most of the time, with the consent of the command staff, will work with the officer in putting the report together. And I had one chief who was adamant, hey, Mike, this is not necessary. This is a clean shoot. We all know this. Chief, I'm doing this for you. And he, what are you talking about? I said, how these reports, which you get one shot to publish, reflect the incident is going to say everything about, at a minimum, the liability of this department in the actions that were taken. And we weren't changing the narrative in any way. We were presenting the narrative in a very clean way that would answer more questions than create questions.
Absolutely. And you go to, for all my cops out there, we know cops aren't necessarily the best report writers. Some are better than others. Some of your detectives, some supervisors, but usually cops they're the street tacticians, right? They're very good at, even from a community policing perspective, we can interact great, but then, reducing that to writing, using a word that you don't realize has potentially an unintended effect, And that's why, again, to your point, we're not changing the narrative. We're just, you have one shot to get it right. Let's get it right.
Right.
Let's take our time doing it.
And while you might be able to go out back and do a supplement, now you're giving a savvy lawyer, especially in a civil rights case or a civil prosecution, you're giving that a lawyer an opportunity to ask questions, create an impression that doesn't exist.
Exactly.
Until you create it. So now let's talk about the different types of investigations. If it's either happening on scene or in the department 72 hours later or right away, whenever it is, it's crucial to know the kind of investigation that we're having. We've mentioned that there's an administrative investigation and a criminal investigation. How do you distinguish between the two?
If you're being ordered to speak, it's an administrative investigation.
Okay, and when you're ordered to speak, and many of people have heard about the Garrity case, Garrity rights. If you're being ordered to give a statement, that statement is considered to be immunized, meaning it cannot be used against you in a criminal proceeding. It can be used against you in an administrative or disciplinary proceeding, and it can be used against other officers in a criminal proceeding, but it cannot be used against the officer giving the statement, right? So if you're ordered to give a statement. Now, if someone shows up in the conference room and they just start asking you questions, no order's been given, nothing has been said about the nature of the investigation, and just let's say, and it might even be good-natured, like concern, maybe the chief or chief of detectives comes in and says, "Hey, Steve, tell me what happened here. What's going on?"
Red light.
Red light.
Stop.
That's great. Red light.
Red light.
Why?
It could be a trap. Intentional or not, the problem is if you haven't been ordered, that statement can be used against you. When you've been ordered to speak, it's an administrative investigation. That statement can only be used in that administrative investigation against you. Unless of course you lie, which then puts that out. But
right.
But when they come in, it could be a trap. It could be an unintended trap. You just know, red light, stop.
Right. So if that casualness, and as we know, casualness breeds casualties, right? Yep. So in that situation, it's incumbent upon the attorney, if they're present, a co-officer or co-colleague, if they're present and the attorney's not, and the officer, him or herself, to say, "Are you ordering me to answer these questions?" And if it's no, stop. Right? If it's yes, the next question, and now we're under yellow light scenario, the next question you get to ask is, will I be disciplined or face discipline if I do not answer these questions? And if the answer is yes, you are now protected. You are immunized. If they say no, you won't be disciplined, then at this point, I respectfully request to not answer these questions until the official investigation commences and I'm actually ordered to do so. The best departments actually have what they call a Garrity form, right? So they just like a Miranda form, and they will put it in front of the officer, and all of this will be explained, and they'll be told that failure to participate in the investigation upon being ordered may result in discipline up to and including termination, et cetera, for insubordination. So it's very, very crucial that you have a clear understanding of the type of investigation. If it is a criminal investigation, and we're going to talk about this in a moment, that's where you consult with an attorney. You never answer questions without an attorney present, and I'm going to suggest you never give a voluntary statement, and I'll explain what I mean by that as we move on. So in this immunized statement, you talk to the command staff. I still would highly recommend that you do this only with a labor rep and an attorney present. And if you are forced to choose between one or the other, you choose the attorney.
Absolutely.
Yeah. Okay, great. Now, the internal investigation is based in policy. Mm-hmm. It does not mean that there isn't a crossover into potential criminal actions by the officer. However, those actions cannot be prosecuted based upon the officer's statement, because it's that immunized statement. And the immunity for what we're talking about is use and derivative use. They cannot use your statement nor anything they discover or derive from your statement, derivative use, against you in a criminal prosecution. So it's a way that the public can be assured that the agency is conducting an investigation to determine that the officer's actions were appropriate and within guidelines. So let's shift gears and talk about the criminal investigation. In the criminal investigation, And in some cases, the administrative investigation on some of these steps I'll talk about. But in the criminal investigation, at no time, under my advice, should an officer ever give a voluntary statement. And I have 4 nevers with regard to these types of investigations. Now, the 4 nevers are, people ask me, seriously, never? I mean, are there exceptions? Well, there's always an exception to a rule, and not necessarily to all of these. And we can have some fun with some of this. And I know that sounds a little odd in a critical incident podcast, but you'll see what I mean. So in addition to the voluntary statement, there are 4 nevers, and I call these Mike's 4 nevers. First of all, never give a voluntary statement. Never. Now, I come from a background in a state where the prosecutors were highly aggressive. They went after police officers. They forced them into grand juries. And if you've given a voluntary statement, and then you give a subsequent statement in the internal investigation, which is compelled, you're required to do it. Now, if there's the slightest discrepancy and you have an aggressive prosecutor, especially in some neighborhoods that are very hostile towards law enforcement, now you're potentially facing a prosecution. Right? Now, one of the things that I love about this, and I hear police officers say this all the time, yeah, but Mike, these are my fellow officers. They're looking out for me. But okay, maybe. I'm going to say they're not. They're doing a job that they're sworn to do. Then swear they're not sworn to look out for you. They're sworn to do their jobs. So there's that. And 2 things could be true at the same time, but let's take a look at what their obligation is. But the second thing is the decision that's being made to file a case is not being made by your fellow officers. It's going to be made by a prosecutor that reviews the statement. And one of the most unfortunate things that can happen is it's a completely reasonable and justifiable shooting, but they pick up on this inconsistency between these 2 statements. And now, at a minimum, you could be placed on a Brady list, which means you're now ineffective to testify, which means now your ability to do your job is called into question, or you could be prosecuted for perjury because both of the statements are sworn. So are these extreme examples? I wish I could say, yeah, but we see them happening all the time, especially the more anti-law enforcement sentiment there is out there, and prosecutors who are in an elected office and want to get reelected by the communities they serve. So never give a voluntary statement. Never. Oh, one other thing that officers like to say before I move on to that is, well, if I don't give a statement, they're going to think I did it. Well, I got news for you. You can't go to prison based upon what people think. Only what can be proven. And I like to use the OJ example. The entire planet believed that O.J. Simpson killed Goldman and Nicole Brown Simpson. They believe it, right? But that belief did not get him locked up, right? Correct. I don't care what people believe about you. I care what they can prove you did, right? So there's that. Number 2, never, and I mean this absolutely, there is no exception to this one, never give a polygraph statement. Never submit to a voluntary polygraph statement. Don't do it. It will not serve you. And if you consent to doing it, now a previously inadmissible piece of evidence becomes admissible evidence. And when I say inadmissible, under the Fry case, a federal case that goes back decades, there is no scientific basis, regardless of what a polygraph examiner will tell you, there is no scientific basis for that polygraph test result. It doesn't prove a thing. It measures nervous reactions, moisture on the body, perhaps whatever it measures, but it cannot say that you're being untruthful. Mm-hmm. However, once you take it, you're consenting to it being administered or to being admitted into evidence, and the polygraph examiner is going to get up there with all the force of what sounds like science behind them and the CSI effect, right? The juries are going to believe that. It's just don't do it. And you want to know what proves that is. I've had some fun with polygraph examiners. So this is where I said we'd have some fun. So we're going to bring the subject in, and we're going to ask him some questions. Great, I'm going to be present. He's my client. Well, no, you're not. Yes, I am. He's got a right to representation under a collective bargaining agreement, and and under the Law Enforcement Officers Bill of Rights, if you have one, I am going to be present for any questioning. Well, you can't, because that will skew the results. Well, how could my physical presence in a room skew the results of a polygraph examination if it's scientifically based? It's just ridiculous. Yeah. It completely is. I've also seen personally with private I've contracted privately with polygraph examiners because the officer made the mistake of actually submitting to one. So we're going to do another one. And I've seen the results skewed by, I didn't have my regular coffee the way I regularly did this morning. So my heart rate's different. I normally chew tobacco. I ran out, or I chewed more than I normally did. I've had all kinds of things that have affected the results. And I've had a polygraph examiner candidly tell me this. So how could it accurately measure anything if I had a half a cup more coffee than I normally do, changes the results? So never do that. Never voluntarily give blood or urine. And there's a couple of reasons for this. First of all, we don't know what your blood or urine is going to reveal. Once you give it, it is now evidence in a public proceeding. So whether you have some health condition, whether you have and if you've ever been to a rock concert, you know that some substances are ingested at these concerts and the smoke wafts through the air. And there have been cases of officers who have tested positive for having a substance in their system because they were incidental, right? Or what do they call that?
Kind of like a contact high.
Contact high, that kind of thing, right? So you want to be always careful about those types of things. Plus, if they want that, it's within your body, within your bodily integrity, they need a warrant for it. They need probable cause for it. So never voluntarily do that. And this is absolutely crucial, regardless of any other exception there may be to any of this. Never, ever, ever, ever talk about the facts of your case to anyone other than your lawyer, a mental health physician or medical provider that you have privately contracted, not one that works or is provided for by the city, and your spiritual advisor, priest or rabbi. And I mean it. I mean, not your spouse, not your life partners, not your kids. You want to talk about the facts of someone outside of those three? Talk to your dog, right? Because your dog can't testify against you. The reason is those three we talked about are privileged under the law, and nothing that you share with those folks and those professions can be used against you. I have seen cases where an officer is involved in something and they've talked about the facts of their spouse and now going through a divorce, and the spouse tends to, twist it, I'm going to get even, that kind of thing. And next thing you know, we're in the middle of an investigation we don't have to be in. So never, ever talk to them. Now, chaplains, our chaplain spiritual advisors, generally no, unless they're ordained in a recognized spiritual discipline. They are not privileged communications. Now, all of these is the peer groups, the critical incident debriefing groups, the chaplains. They serve an amazing function and to bring peace and tranquility to the situation, to help you, off-gas the stress, for example. However, they are not privileged. And so sharing the facts of the case does two things. It puts them in the crosshairs of potentially being subpoenaed, and it puts facts out there that, once again, can now be inconsistent with a previous statement that's been given. Anything you want to add to that? That was a lot.
I think that's the hardest of the four no's. That's going to be the hardest for our officers out there because they come from the human gene pool. They're social. They know that they didn't do anything wrong because they responded for that call. They did their job and they want to prove it. Yeah. And that is the biggest of those four no's. They have to remember that. Even me as the labor rep, when I'm there just to make sure that the process is being followed. I don't have that privilege either. It is critical that they not talk about sports, anything else to keep that emotional trauma at bay and psychologically decompress, but not about the incident.
Not about the incident. Now, is there an exception to never giving a voluntary statement? And then people say to me, "You never give a voluntary statement? Really?" Well, really, unless. Now, we've already talked about the public safety statement. We talked about that in part one. And in that, you're stopping short of, then I did this, right? Whenever you come to the point where you're going to describe your personal actions in it, you stop. But the public safety statement is one exception. The other exception is this. When there is a free exchange of information, it's a voluntary statement, and it's in a criminal investigation. It's a voluntary statement because you're not obligated to give it. You have the right to remain silent, period. So if an investigator wants that statement, I have a few conditions under which I will make an exception to the never give a voluntary statement. The first one is the investigation's concluded. There is nothing else that is left to be done. There are no witnesses that need to be interviewed. We know where all of the potentially injured or fatal shots were. We know all that stuff. They're done, right? And the statement is being given because there is an intention to release to the media, to the public, that the officer cooperated with the investigation. And that also means that the officer is cleared. It's already been deemed to be a reasonable shooting. Now, the last thing that I absolutely am adamant about is that statement is given to a prosecutor, not to a detective, not to a law enforcement officer. Why? Well, I'll go back to what I said earlier. It is only the prosecutor that can make a filing decision. When it's released, when the statement is released from the prosecutor's office that they're cleared and the officer cooperated, that's the end of it. That's it. Now, with the prosecutor, then, I am going to also have a conversation with them that says, we want to know the questions ahead of time. We want to know the subject matters you want to go into. And I also want to know if you have any concerns or questions about the underlying investigation that you have any insecurity about in releasing a statement that the officer was cleared. And when all that is, when we are at a level of trust on that, then we're good to go. And then I'll say, okay, let's do it. And it's going to be your term, perfect, narrowly tailored to that event. We're not going into the officer's private life. We're not going into their extra duty or any of that other stuff. It's just that incident, that night, those details, that's it. And I found that by and large that people are very cooperative, very reasonable around that. And I have had a prosecutor lie to me. So now the other thing that I'll do is, if we're going to give a voluntary statement, it will also serve as the administrative statement. So we're not going to give a second statement to Internal Affairs, one statement and one statement only. And if the prosecutor is inclined to say, okay, I will rely on the Internal Affairs statement to close the case, even though, because they can't use to prosecute the case, but they can say, yes, the officer gave a statement to investigators and we are satisfied that this is a reasonable shooting. But all of that gets discussed ahead of time. And of course, never before that for initial 72 hours. Anything you want to add to that?
Hit it 100% on point.
100%?
100% on point.
All right. Now, there is also, as we talked about, there is going to be the administrative investigation, the Internal Affairs investigation. And as you might have guessed, that is part of another podcast. We're going to have a podcast in the future around representing your members, what those Internal Affairs investigations look like. So make sure you stay tuned for the announcement on that. For Steve, for myself, thank you for tuning in. We look forward to seeing you on a future broadcast.